of our topic, which we are going to be looking at players in the business environment. And of course, we will start with states. And the previous exercise would be very useful for us to understand the nature, the role of state in regulation of business environment. So one of the roles is states as rule makers or state as a legislator. Of course, this is one of the primary roles of a state once we talk about business law. And of course, state is the one that creates national law, which would be applicable to business, which would regulate business and also to enforce national law. And apart from that, states also conclude international treaties. We looked at the typology of international treaties in the lecture number 1. Here we're talking about agreements under public international law, all kinds of commodity agreements, bilateral, multilateral trade agreements, and so on. There is the whole range of them, which are crucial for business as well. How to apply international treaties we also discussed during the lecture number 1. Important further element is the implementation of international sources. This is exactly where we are talking about so-called harmonization or unification of law. So these are those conventions which try to unify business or private law of different states. What examples of conventions I can give you and which organizations are involved in these efforts to unify domestic legislation, we will also be discussing today a bit later. And of course, states create those international organizations, international institutions, which provide a very useful help, very useful assistance in harmonization of domestic business law, but not only, also providing all kinds of services to business, also providing dispute resolution means, and so on. And again, what exactly functions international institutions play and which role they play in regulation of business environment, we will be discussing within today's lecture. So as you can see, states indeed play a crucial role if we look at the role of a state as a legislator. However, there is another capacity in which states can also act in business environment, and this is states as trade partners. As already we saw from the previous exercise, states indeed can enter in the contracts to obtain or sell goods and services for use by the government or by its citizens. Again, it might sound a bit unusual for us, but nevertheless, states can act as private person. What it means as well, that would be the objective of discussion for today's lecture. States can enter in the contracts directly as contracting partner, or what can be done is the creation of state companies or all kinds of mixed enterprises, joint ventures. So there is a large variety of those, but these are two ways for states to enter in the contractual horizontal business relations. And the important conclusion that we can make from that is that state can act in two capacities. State can be a public person, where we have all these beautiful attributes such as sovereignty, immunity, jurisdiction, enforcement, and so on. And state also can act as a private person by entering into commercial deals with companies and other states as well. And there is a very important legal distinction between these two roles of state. And distinctions lie in the immunity, state immunity. What it means? State immunity means that in case of litigation, you cannot really use the courts of foreign states to protect your rights or to have litigation at all. And let's try to understand why we cannot have this option. The thing is that states are sovereign, but not only, they're also equally sovereign, meaning they are equal between each other. And if we allow one state to sit in judgment on another, that would mean that we would violate this principle. We would put one state above the other. And from legal perspective, this is not possible. Although we understand that in practical reality, of course, states are all different. There are powerful, strong, wealthy states, and there are those which are not at all. But from legal perspective, they are all equal. And sovereign immunity and sovereign equality is something undeniable. It's one of those customary rules of international law which exist in objective reality. This is so-called natural law. You remember we talked about it during the first lecture. And this rule, this principle exists in unwritten form, meaning you don't have to have a convention, you don't have to agree upon that. That's not a positive law, it's natural law. Nevertheless, there was an attempt to codify these rules with regards to state immunity, and in 2004 the convention was adopted, the United Nations Convention on the Jurisdictional Immunities of States and Their Property. However, this convention is not in force, meaning there was not sufficient number of state parties for this convention to enter into force. What does it mean for us? Does it mean that the rules stipulated in the convention are not applicable? Not at all. That only means that for states it's okay to continue living with the customary norms which are still there. You don't need to be party to convention to respect these rules and to follow them. So be aware of that. State immunity rules are customary, and when we talk about state immunity, we should distinguish between two types of act of state. When state is acting for public purposes, state will have immunity from foreign courts. When state is acting for commercial purposes, there will be no immunity, and indeed a state can be judged in a court of a foreign state. So now, important thing which I must mention so that you are not confused, we are talking about only using foreign courts. There is no immunity of a state against its own courts, of course, and we are not talking here about different other alternatives, ways of litigation which exist in public international law. For example, we're not talking about international courts, and we're not talking about states being able to solve their disputes directly between each other, because this option also exists. And not necessarily it would be applicable to business law, that's why we're not discussing this within this course, but these options are still on the table. Right now we're talking about purely commercial matters where state can be judged by courts, domestic courts of a foreign state. So that would be possible if state acts for commercial purposes. So of course, to illustrate these options, what it means, public purposes of commercial purposes, we'll look at a couple of cases, again, just to make it more material, more visual for you. Now, of course, public purposes, that's where state acts with sovereignty, and these are such things as waging wars, for example, entering into military alliances, and so international cooperation, everything which is within the domain of the public international law, human rights as well, that's also one of the examples. So that would be public purposes. Now, commercial purposes, we understand, that's anything business related, all kind of deals, buying, selling, and taking loans, and so on. So, and as I promised you a few cases, let's look at them. As you can see, I give reference to the article of the convention. It doesn't mean that you have to check convention, although you can if you wish, but already the distinction between public act and private acts is sufficient to answer to the questions which go together with these cases. So in this particular example, there were relations between UK company which supplied large quantity of cement to the Nigerian Defense Ministry. Then there was a change of regime in Nigeria, and the new government decided that they do not need the cement. Well, cement was already delivered and they didn't want to pay for it. So the supplier, the UK company, brought proceedings against Nigeria in the UK courts. And the question for you, whether that would be possible, whether Nigeria will have immunity in such case. You can stop the video, take your notes and argumentation, then we will come back and discuss. So obviously we are dealing with purely commercial relations, commercial transaction, and Nigeria will not have any immunity. Of course, the money for cement has to be paid and litigation can happen. Another example is more peculiar. I try to move from simple cases to more sophisticated and unusual. This is the case which happened in Czechoslovakia after the Second World War, where the country went through nationalization. So the factories were taken away from private owners, and this happened to a factory which was producing perfumes. And further, the Czechoslovakia, the state continued to produce perfumes under the Czech national name. And the previous owner of the factory sued Czechoslovakia for trade infringement. And the reply from Czechoslovakia was that, well, selling cosmetics is our official governmental function, so we're immune and we cannot really have any lawsuits. So the question for you again would be to answer the question whether there will be immunity in this case. You can stop the video and then we will come back and discuss. So in a way it might appear right, because if you probably know, socialistic countries indeed thought that factories shall belong to the state and production should also be happening under the state. However, this is not at all an official function if we look at formal elements, and trademark infringement is a serious offense, and that's exactly what was happening, and Czechoslovakia will not have any immunity in this case. So this is again a case which is a bit tricky, but nevertheless quite interesting. And another case which I also find quite unusual and useful for us to look at, so that we understand the difference and try to get the feel of what is commercial activity and what isn't. We know that Argentina has been going through quite hard financial times, and there was a series of financial crises, and Argentina kept on borrowing money which it was not able to pay back. There was a series of defaults, and the question for us is borrowing money by the state from banks, let's say foreign banks or foreign partners, creditors, would that be a sovereign activity? Because in fact the state is borrowing money for its own needs to fund its existence. So I will let you also stop the video and then we will discuss your decision. So as I mentioned, this is a quite peculiar case, and there are lots of interesting academic articles written about sovereign defaults and debts of states. So in fact Argentina will not be immune, because although it took the money for the purposes of state functioning, and it was like a sovereign debt and sovereign default, nevertheless this act of borrowing, the acts of borrowing were in fact commercial, so there will be no immunity whatsoever. The problem, although, with the states is that if you are trying to sue the company for to try to return your debt, the company in fact can declare bankruptcy, while this never happens with states. States cannot really declare bankruptcy, so it's a bit complicated. And what happened in the case of Argentina, they just tried to restructure the debt and delay payment. So it's not that straightforward with states when they borrow money from commercial creditors. But nevertheless, be aware of these legal aspects of such situations. Another element which worth discussing, as long as we talk about states and their role in the commercial or business relations, is expropriation. What might happen is that your property, let's say you are a foreign company or individual entrepreneur which has certain commercial property abroad, in fact a state is not prevented from expropriating the property of foreign companies or foreign individuals. So be aware of that. And you also cannot take for granted or assume that you will have the same rights as nationals in terms of owning property abroad, commercial property abroad, or any type of property as a foreign company or alien. So there might be special restrictions, which is normal for states. They of course try to regulate this. This can be quite sensitive for a state, so it's normal to have restrictions towards foreign companies or foreigners. Please do not see it as a discrimination. or violation of some human rights or whatever rights. So this is normal, and states have the right to do so. What states do not have the right to do is to have different rules for their nationals and foreign companies when it comes to protection their rights in court. So access to courts shall be on equal footing to nationals, meaning that you shouldn't be discriminated at that stage. But otherwise there can be restrictions, and in fact state can take your property. Here we need to distinguish between several ways how property can be taken. It can be straightforward expropriation. This is the case where the compulsory deprivation of property is happening, but you get a compensation. So the reasons for that can be different. Maybe there can be environmental reasons, or can be some public purposes. Maybe they need to construct a road exactly where your commercial manufacture of your factory is located, or there has to be a reason for that. The other option is nationalization. That's exactly the example which I gave you a bit previously with Czechoslovakia, where the whole industry is being nationalized. So that's general expropriation. That doesn't happen that often, but who knows, that might happen. Just be aware of these options. Some states can follow this path. So within your commercial business activities, just be aware of that. The other one is confiscation. This is a situation when property is taken without compensation. That happens usually as a punishment for certain infringement, certain crime, certain offense. We will have a special topic, business and crime, and we will be looking at that in further detail. And there can be also sequestration. This is the taking possession of property temporarily, but the legal title remains with the owner, with the foreign company. So be aware of these options, these distinctions as they exist. And another element worth mentioning is once we talk about expropriation, if you want to protect your case in the court, there are certain factors which you need to be looking at. First of all, whether the expropriation was done in accordance with proper legislation or it was done arbitrarily. Of course, your case will be a bit stronger if it's done arbitrarily, but if you have legislation, then probably everything was legitimate. There is not much you can do. The other factor is whether it was done for public purpose or some other purpose which might not be so justifiable. And the environment concerns, that's a bit tricky, so not always probably it can be sufficient. The third factor, whether aliens were discriminated against. So here your position can be very strong or way stronger once you end up in a court defending your rights, if there was this discrimination done at the situation of expropriating, like we expropriate only from the foreign companies but not from the nationals. So here can be a bit different situation. And the fourth factor is whether appropriate compensation has been paid. So if in fact it was paid and it was appropriate, so that is just an end of the story. There is not much to discuss. So and another element worth mentioning is that expropriation can be done also indirectly. For example, soldiers can be sent to occupy a factory and replace all the managers with local officials. So this sounds probably a bit savage, but nevertheless that can happen in some situations. Just again be aware of that. Another way to expropriate indirectly is to impose penal rates of taxation on certain types of companies to drive them out of business. So that practice also exists and that can happen. Be aware of that. And another way of indirect expropriation is to perform an act that causes significant diminution in the value of the property. So that also another way to take away property indirectly. So these are so-called pitfalls which we need to be aware of if we have our business or have our commercial property abroad. The further thing which we need to look at, as long as we talk about players, is international organizations. If you remember throughout the lectures, I have been mentioning role of international organizations and soft law and decisions of international organizations. So now is the time to talk a bit more substantially. So we will be looking at concrete examples of organizations. And our idea, our objective is mainly to set the scene and to illustrate the landscape of international organizations and to identify the ones which are the most influential in terms of regulation of business, in terms of helping states to choose approaches to unification of regulation of business environment. So here we need to distinguish between restricted organizations such as OECD, OPEC, G20. These are organizations which have so-called closed membership, where not any state can join. So it's like a bit different nature. And we have also universal organizations which are in principle open for everyone, such as WTO, United Nations, UNCTAD, ILO. ILO we will be discussing once we talk about labor standards, UNIDROIT, and High Conference on the Unification of Private International Law. So these are organizations which are widely open. As you can see, the majority of organizations we will be looking at, and the ones which are active within business law, are international. However, we should also be aware of a number of trade organizations, free trade organizations, which are typically regional or sub-regional, or sometimes they cover specific group of states which have close trade relations. So be aware of those. These are usually the organizations which are created under agreement for free trade zone, customs union, common market, or monetary union. This could be quite useful for you to do business with, because once you are in one of those free trade zones or custom unions or monetary unions, you will enjoy a special regime. Of course, under condition that you as business also come from one of those countries which form such a regime or such a union. We will not be going into details because there is quite a large variety of institutions, but just to give you a few examples, this is European Union, of course you know that very well. There is EFTA, European Economic Association, there is NAFTA, there is CAFTA, which covers Central America, Mercosur, CARICOM. NAFTA was replaced recently by the agreement between the United States, Mexico and Canada just recently, 1st of July 2020, and also South Asian Association for Regional Cooperation with the South Asian Free Trade Zone. We have also Canada and Europe Association, which is applied provisionally. We have also Common Market for Eastern and Southern Africa and so on. So there's a quite large diversity of such organizations. As I said, once you are doing business within one of those unions, you will enjoy certain benefits, certain regimes, but also certain rules which you have to respect and follow. So be aware of those. And we will look mostly from the perspective of organizations which contributed to the unification or providing unification of business law or providing certain services which are crucial for business. So we'll look at a number of organizations such as EU, UN, WTO, Council of Europe, OECD, and UNIDROIT. So this would be our brief overview. Of course, you know that United Nations is a central organization, international institution for the world diplomacy, and the major objectives of United Nations is to maintain peace and security. This is the organization which was created after the Second World War, and the main mood was never again. So we will never let the Second World War happen again. So that's the main, or one of the main ideas of this institution, to ensure that peace is respected. So that's the function of Security Council, but not only, also to cooperate in a number of areas such as economic, social, cultural, humanitarian problem solving and so on, and to promote respect for human rights and international freedoms. So as you can see, the scope of this institution is quite vast, quite diverse, but what is important for us is the United Nations Commission on International Trade Law, so-called UNCITRAL. So this is the commission, the organ of the United Nations, which has a very important task of harmonizing and unifying the law of international trade. So the harmonization and unification, as you know, is quite a crucial thing. We just cannot live with vast diversity of domestic legislation approaches to business. So as a result of the work of this commission, we have a number of new international conventions, model laws, and uniform laws. So already throughout the course, I will be giving you quite a few examples of conventions, and we will be working with such conventions which were developed, produced, and promoted by UNCITRAL. So the examples of such conventions just at this stage, so that you can imagine the contribution of this organ. This is the convention which I already previously mentioned, the UN Convention on Contracts for the International Sale of Goods. This is the key document we will be discussing within lecture 4. Also very important convention, UN Convention on the Carriage of Goods by Sea, the Hamburg Rules. There is also a number of model laws. We discussed with you the nature of model laws during the first session, during the first lecture. Model laws usually followed by states to generate their own domestic legislation. And this is very helpful because it's important to have certain experts who would analyze the practice of states, who would analyze also domestic approaches, domestic legislation, and produce something which is acceptable, which is digestible for different legal jurisdictions, domestic legal jurisdictions. And just to give you a few examples, this is the model law on international commercial arbitration. There is a law on electronic commerce and model law on cross-border insolvency. So as you can see, quite a wide range of topics is covered already by either conventions or model laws. And just to mention that UNCITRAL is really institution organ with quite wide spectrum of issues they work on. Usually they work through creation of working groups. You can look at the website what exactly they're currently working on, as the thematics of the working groups is constantly changing. I just give you a few examples, just a few examples. In fact, there are way more working groups and way more thematics, but just to illustrate you the approach of this institution. For example, they work on the privately financial infrastructure projects. This is one of the working groups. On the international arbitration and conciliation, on the transport law, insolvency, security interests, electronic commerce. So this is just to give you the feel of how large the scope of activities of this commission is. So basically this is a very, very helpful organ, and we will be referring to this institution quite a lot throughout the course. And of course you all heard about World Trade Organization, who is the successor of General Agreement on Tariffs and Trade, and the main objectives of this institution is to promote the free flow of trade by removing obstacles to trade. The functions of WTO are quite wide. Just to mention a few, this organization supposed to and does such important functions as administers trade agreements. It acts as a forum for trade agreements, settles trade disputes. They have quite efficient dispute settlement body, which really does excellent job and really works very efficient, and the case law is enormous. It also reviews national trade policies, and of course WTO assists developing countries in trade policy issues, providing all kinds of technical and assistance and training. So this organization is really crucial for international commerce, international trade. Just to highlight that the main approach of this organization is to work with states to help them develop their domestic policies. It's about states. It's not an organization which works at the level of businesses or companies. It's just purely how states will harmonize their approaches to the free flow of trade and how they remove obstacles to free trade. And here, what is important for us to know, of course, it's a huge topic and it wouldn't be possible to talk about it in detail, but what is important for us to know at this stage, for you, once you once you do business, you need to distinguish the major principles of international commercial law. These are the approaches which states follow. They have certain terminology which, well, ideally you should know, because that's something which you can benefit during your actual business activities. One of the principles is most favored nation principle, so-called MFN. So what it means is that any advantage to a product originating or destined for another country shall be treated in accordance with the like product originating in or destined for the contracting country. So it's a bit a strange term. Why do we call it most favored nation if we're just talking about treating in accordance with a similar product originating from our own country? But nevertheless, be aware of that, and once you do business with a specific country, just check the legislation, the conventions which are adopted on what has been agreed upon towards your specific country. Maybe you will be able to benefit from this particular principle, and that would be really great news. The other principle is national treatment principle. Here we are talking about that no discrimination will be done between imported and like domestic products other than through imposition of tariffs. The tariffs are possible, but otherwise no other discrimination. So that's also not a bad thing to have. And the other one is reciprocity principle. This is the approach which WTO follows to encourage negotiations between members and to encourage them to reduce tariffs and other charges on imports and exports. So which is something which is normal for states to try to protect their internal market. So WTO is trying to remove those limitations so that there is a free flow of business. So these are the main elements which we, at least in a very general way, need to keep in mind with regards to WTO. I'll briefly mention Council of Europe. The area and the scope of activities of this organization doesn't have direct connection to business. It's way broader. It's more about human rights, pluralist democracy, and the rule of law, and also solving problems which Europe faces currently, and to promote also democratic stability in Europe through political, legislative, and constitutional reform. And one of the important features, one of the important field of activities of Council of Europe is legal cooperation in Europe. This is where we already will have connection with business law. For example, Council of Europe is focusing on harmonization of national legislation, improving judicial procedures, and of course looking for common solutions for modern problems. So with regards to business, what is important for us is the conventions related to corruption and extradition. Once we talk about business and crime, we'll come back to those examples and we'll look at them in detail. And apart from that, Council of Europe also adopts a number of recommendations which are so-called soft law. Nevertheless, they are followed because they are political documents. And again, just to give a couple of examples related to business, this is a recommendation on human rights in business from 2016, and Working Party on company and corporate law, where the main focus is corporate governance, corporate social responsibility, accounting, and auditing. So there is a certain connection with business law, and more specifically solving legal problems, harmonizing legislation, and helping to improve judicial procedures. But be aware of that. Don't mix this organization with European Union. European Union is a completely different institution. It's a political and economical union, while Council of Europe is more about democracy, law, culture, solving problems which Europe faces. And just to give you an example, the of course famous European Convention on Human Rights was adopted specifically by the states members of this organization, and European Court of Human Rights was also created to help implement that particular convention. So that's the convention and the court which were created within Council of Europe, just to so that you place it in the right box in your mind. And another organization which we will look at is the Organization for Economic Cooperation and Development, OECD. This is one of the examples of so-called restricted organizations. The purpose is to be a forum to discuss, develop, and refine economic and social policies. And the organization is helpful in adopting both legally binding agreements, for example, in relation to bribery, we'll get back to that once we talk about business and crime, and non-binding agreements, for example, guidelines for multinational enterprises. There is a very helpful organ which exists within this organization, Directorate for Financial, Fiscal and Enterprise Affairs. That's already you feel how close it is to business law. And the main focus of this organ is corporate responsibility. And for example, there was a number of principles adopted, a number of guidelines and declarations, such as principles of corporate governance from 2004 and corporate social responsibility, guidelines for multinational enterprises, declaration of international investment and multinational enterprises, and so on. So this is the angle from which OECD approaches business law, business environment and cooperation in the area of commerce. Just be aware of that. These are quite useful documents, but this is the organization which focuses on these particular matters. And from legal perspective, what is absolutely crucial for us is to look at International Institute for the Unification of Private Law, UNIDROIT. So this is already, we see from the title, from the name of the institution, that's the main objective is to modernize, harmonize and to coordinate private international law and in particular trade law. The organization is very old. It was created in 1926 and it adopted quite a few international conventions which modify mostly substantive norms. Yes, the conflict of laws norms might be also unified, but that's done not purposefully. That can happen accidentally. But mostly it's about unification of domestic legislation. So as you can see, again, we are dealing with something crucial and very helpful for us if we want to do business internationally. And apart from international conventions, UNIDROIT also is quite productive with producing model laws, general principles, legal guides, and so on. So that's something which states, again, can use to generate their domestic legislation, or businesses can use them directly. For example, one of such documents which is absolutely helpful and I indeed recommend it to you is the Principles of International Commercial Contracts from 2016. This is the document which was created specially for businesses, especially for companies, so that they can refer to such rules, to such principles doing their international business. So that makes their life again easier. They don't have to invent rules or practices. They can just use already something which was developed specially for them. So this is also one of the institutions which is extremely helpful for development of business law, and we will be referring to this organization and to the legacy which it produced. And the next thing we need to look at is the non-governmental organizations. Before, we have been looking at governmental institutions which were created by states, for states, through international convention, where we have also state participation, and even you could see that the focus was also on harmonization of legislation, or producing guidelines and model laws and so on. Here I'll just give you a few examples. The crucial NGO, non-governmental organization, where we do not have state members, would be International Chamber of Commerce. Here again, we will have businesses which are parties, which are members to this institution. We will have International Accounting Standard Board, we will have Comité Maritime International, Institut de Droit International, Carnifolium Corporation, standard setting organizations, World Economic Forum, and so on. So there are quite a lot of them, but we'll be looking specifically at International Chamber of Commerce, because this is where we have really big a significant role for business law. Again, this institution was created quite long ago, in 1919, with the objective to serve world business by promoting trade and investment, open markets for goods and services, and the free flow of capital. So it's a great objective. As I mentioned previously, the members are not states but businesses. So all kind of there are like dozens of thousands of business entities and business associations which are party to International Chamber of Commerce. Important to know is that International Court of Arbitration was created and functions within International Chamber of Commerce, which was created in 1926. And International Chamber of Commerce also provides a number of services which help you, guide you through the resolution of your disputes. So, with regards to the documentation, ICC produces codes of practice, which can be also useful, delivers different practical services to businesses, and combats commercial crime. So I mentioned already a very crucial function with regards to dispute resolution services. We will be coming back to that within the topic on dispute resolution. But what is also very important, the contribution of ICC to unification of international commercial terms. You can really get lost and really be confused if you use different terminology. Plus, also language differences go on top of this complexity. So what ICC did, they unified the terminology of logistics and transportation and delivery of goods, international delivery of goods through Incoterms. This is a document, there are actually a series of documents which has been renewed throughout the years, and the recent version was from 2020. We will be looking at this document once we talk about international sale of goods, but you will see how useful this document and this approach is to help international business unify their language. They can just use a brief, just abbreviation, just to explain what set of rules would be applicable to their contract. So this is something really which makes business life way easier, and we will be looking at Incoterms in detail in lecture number 4. And the last thing which we need to look at today during this particular lecture is businesses themselves as players. First thing worth mentioning is that legal forms will be dependent on national law. International law practically doesn't deal with that. You saw from previous examples I gave you that sometimes indeed international institutions try to produce certain guidelines for corporations, but we didn't achieve yet any unification at the universal level. Although at the level of Europe there is European society, as they call it, but nevertheless that would be domestic law which would govern the forms, the legal forms of businesses. It can be natural persons, physical persons, individual entrepreneurs, or can be other types of legal personality. We will have a special topic where we will be looking at that. Could be also incorporated organizations. Within our lecture especially dedicated to this matter, we will try to look at commonalities and distinctions between different jurisdictions. But within this particular topic, we'll be just trying to look very briefly at rights and obligations of business, which can come from national law. Of course, primarily that's the law which shall be applicable to business. Sometimes directly from international law, for example, in case of investment, but we already know that international law can operate directly on the territory of a state, and that's totally normal. Businesses can also create their own rules. How this happens, I'll explain you just in a minute. But there are also there's also international soft law which can be applicable to business. Just to give you an example, United Nations Human Rights Council Guiding Principles on Business and Human Rights from 2011, but also when I was giving you the overview of international institutions, you also saw that there is a number of guidelines which are addressed specifically to enterprises, to businesses, and that's also an example of soft law which would be applicable to businesses. And another important element is that businesses are subject to insolvency proceedings, while states as business partners are not. So that's something we shall be keeping in mind. And very briefly, just to go through main obligations of businesses. Of course, businesses shall not be involved in unfair commercial practices. They should respect rules on advertising and marketing. By the way, International Chamber of Commerce created some of those rules. They should abstain from agreements and practices which restrict competition. They should not be involved in corruption and bribery. We'll have topics on that. They should also provide financial information. There are also obligations regarding transparency. Of course, businesses have to pay taxes and to provide relevant information. There are a number of obligations with regards to labor law or employment law. We'll have a special topic where we'll be looking at that. There's a number of obligations with regards to environmental protection, public safety obligations, more specifically product safety, and we will be also looking at product liability and liability for unsafe products. We will have a special topic dedicated to torts or delicts, and we will see what rules are applicable to businesses, what remedies are available in court, and how you can protect your rights if you ended up in court for product liability. Apart from that, businesses are obliged to respect intellectual property rights. For intellectual property, we will also have special lecture. We will be looking at a number of conventions and also how the matter is tackled by domestic jurisdictions, and also we will be looking at, again, how you can protect your rights in court if you end up in court. There are also obligations to respect data privacy, to protect data, and to respect universal service obligations for operations for telecom, electricity, postal services, and so on. And what is important to know on the good side, and the good news is businesses can also be rule makers. You remember when we talked about states, I started the topic by saying that in fact states are rule makers, but businesses are also. Within private law, we do have freedom of contract, where businesses have the right to create their own rules, even to choose which domestic rules of domestic jurisdictions they want to apply to their contracts and which courts they will be using if they have disputes. So there is a lot of freedom, and that's a very good news. And once we talk more specifically about contracts and about dispute resolution, we will look more precisely how this can happen and which options businesses have. And of course, businesses do have liabilities which come out of contractual obligations, such as contractual liability and so on. This we will be also looking at within the topic liability, torts, delicts, and so on. So I think this lecture was quite comprehensive in terms of overview of sources and players, and we probably shall be finishing by now. In the next lecture, we shall be looking at contracts. We'll start with approaches of domestic jurisdictions. We would need to understand the theoretical and practical approaches which were generated by domestic law before we will be moving to international contracts, which we will cover within lecture number 4. We will be looking at convention, and we will be looking at practices, examples, exercises, and so on. For the time being, thanks for your attention, and I see you within the lecture number 3.